Ladies and gentlemen, I have the pleasure now to introduce you to the third panel for today, the last one, Data Protection and Competition as Converging Digital Regulation, from Theory to Practice. And we will have a full panel that will be moderated by Wojciech Wiewiorowski and panelists Ulrich Kelber, Orla Linsky, Rohit Chopra, Giuseppe Buzia, and Maria Ioannidou. So, ladies and gentlemen, we are expecting panel 3 on the stage.
I would like to welcome you at this panel, which will touch one of the subjects which is right now in the heart of the discussion all over the world, especially in the region which I'm coming from, in Europe, and in the United States. But actually having a lot to say in all the continents and in all the jurisdictions. Competition law, antitrust solutions, that's something which exists in the jurisdictions all over the world already for decades. The data protection law sometimes is a new phenomenon in the legal order of the states. So also the regulators which exist in both of these fields are organized very differently from country to country. But we start to find out that the topics that we touch, the tools that we want to use, are more and more similar. There is a kind of interest, sometimes even a fear, among the organizations about the use of these powers and synergy. There is also a kind of interest and pushback from the regulators themselves. In some of the jurisdictions where these regulators are working separately, the competition ones, the consumer protection ones, the data protection ones, there are the talks about merger of them and creating one big co-regulator for all the subjects which are connected with the digital world. In the other jurisdictions, where there is a regulator who is at the same time dealing with the consumer issues online and the competition issues, or this part of the competition issues, there is a discussion if they should be split. I actually don't know what is the right answer, and I don't know how it should look like in the longer perspective, but I will have the opportunity to talk about that with all of you with the help of a distinguished group of speakers. Speakers who have practical experience and who come from the jurisdictions where this subject is part of the ongoing discussion. Ulrich Kelber. Ulrich Kelber is the Data Protection Commissioner on the federal level in Germany, and he used to work also in the parliament. He was a parliamentarian. I think you were a parliamentarian for almost 20 years. And at the same time, has the background in IT and is a commissioner on the federal level in Germany from January 2019, and in July 2019 was taking part in the conference that we organized together, the German Federal Commissioner for Data Protection and the European Data Protection Supervisor, which was another one in the line of the discussion on this subject that Peter Hastings has started back in 2012, 2013. And Germany is the heart of the discussion about the reuse of the tools of the competition authorities for regulating the things which were so far connected rather with the data protection and with the use of the data. Orla Linsky is an associate professor of law in the Department of Law of the London School of Economics. She is teaching digital rights, IT law, EU law, and is the strong advocate on interplay of law related in the data protection field, in the competition field, and in consumer protection. And she will give us the academic background, but also the comparative approach to the subject. Then the next speaker will be the representative of the American administration, Rohit Chopra, the commissioner from the Federal Trade Commission. using the tools of consumer protection, as we would call it in my jurisdiction, competition, and data protection, being here as the data protection commissioner from the States. And we have also with us Giuseppe Bussia. Giuseppe is the Secretary General of the Italian Garante, which is the data protection authority. Garante, which was always in the front line of the discussion about the approach to the data brokers, approach to those who are the big collectors of the data, from the perspective which is not only the data protection one. And finally, but probably the most interesting for all us data protection authorities here, we have Maria Ioannidou with us. Maria was recently appointed the Commissioner for Hellenic Competition Commission, Hellenic Competition Commission, so the Commission for Greece. And her area of interests are, among others, in interaction of competition and consumer law, as well as the problems of the big data and artificial intelligence in competition law enforcement. She is a senior lecturer in competition law from the Queen Mary University. I guess that this combination of the practical approach and the scientific approach will be the good summary of the discussion today. But just to start to think about the subject, let me use some of the slogans that we hear all the time and that we have to take into consideration. So, the largest firm in the world by market capitalizations are in digital sector. They are data companies. They accumulate such an extent of superior information and knowledge over individuals, societies, and competitors to make the whole game of competition not meaningful. Digital markets are increasingly more concentrated. There are some market characteristics which explain this, but the rest is simply the pace of merger and acquisition in the tech, which is simply astonishing. And there are increasing concerns over availability of the big tech to accept manipulation and even derail of the democratic principles. Data accumulation in the hand of few large companies shall be big strategic priority for the privacy and data protection community. These are the things that we hear. These are the things that some of us are saying. And I would like to ask all our participants of this panel to have their say on the subject, and then we will go to the questions from the audience. You have the application to pass the questions to us, but let's start with the position of our panelists. Ulrich.
Yeah, thank you, Wojciech. I'm still on?
Well, I can hear you, but I'm quite close.
Yeah. That seems much better. Thank you, Wojciech, again. So data are a billion-dollar asset, and so a decisive competitive factor. And out of that, there are numerous interconnections between data protection and competition protection. Data protection violations can be relevant under antitrust law. And on the other side, data protection cannot ignore the economic realities and the importance of the data economy. If, for example, a company forces data protection consent to the processing of personal data and on the basis of its market power, then the question of the effectiveness of such consent as well as the antitrust question has to be answered. One must be aware of these interconnections, and that is why the exchange between authorities and the discussion in the specialist public play an important role. I welcome the order of the German competition authority, the Bundeskartellamt, against Facebook. The Bundeskartellamt based its orders on the collection and use of user data that was not permitted under data protection law. Andreas Mund, the president of the Bundeskartellamt, justified the decision with the following words: on Facebook, we are making a kind of internal data unbundling for the future. Facebook must not longer force its users to agree to a de facto unlimited collection and allocation of non-Facebook data to the user account. Against the background of the decision of a court in August to suspend this order, we must also be aware of the limits of such interconnection. In its decision, the court expressed doubts as to the legality of that order of the Bundeskartellamt. It's true that not every breach of data protection law justifies the assumption of a breach of antitrust law, but however, many observers are of the opinion that the court did not sufficiently include either the 2017 amendment to the German antitrust law, nor the GDPR of 2018 in its ruling. So the cooperation and exchange of data protection supervisory authorities with other competent authorities, such as antitrust, are necessary in order to ensure a current application of law. The powers granted by the GDPR in the European Union to data protection authorities and the antitrust powers of competition authorities are effective tools that can complement each other in the fight against the abuse of data power. It's now a matter of exploring the limits of cooperation and making the most effective use of legal possibilities. This is the only way we can guarantee the digital self-determination of our citizens.
Thank you very much. Can we go to Ola?
Thank you. With my few minutes, I would like to make two key points. So the first is that competition and data protection are interdependent. And in that sense, they can't be looked at in regulatory silos. And I'll give an example of that. And then the second point is that we currently see that there are some blind spots or gaps in competition analysis that then have a significant impact on the effective enforcement of data protection. So if I turn to that first point, the interdependence of data protection and competition, I think the first thing to note here is that data protection needs effective and competitive markets in order to itself be effective. So we increasingly recognize within the data protection community that although individual rights are a necessary part of data protection and individual control over personal data is a necessary part of data protection, it is unreasonable to place the onus on individuals to themselves guarantee their rights in the digital environment. And Georgetown law professor Julie Cohen puts this very nicely when she says we need to turn privacy inside out. We need to move away from the individual-centered model of data protection and start to look at the material and social conditions in which data processing takes place. So in other words, we need to look at the environment where data processing takes place. And that's what brings data protection to connect with competition law. But competition law itself can't operate in a vacuum without a consideration of data protection constraints. So a classic example of this would be that market definition, which is the first step in any competitive analysis, whether that be of an anti-competitive agreement or an abusive dominant position or a merger, requires an assessment of the relevant market, and that includes analysis of the relevant legal and regulatory landscape. And data protection law forms part of that legal and regulatory landscape. So a good example here is something like data portability. Once data protection frameworks introduce data portability, that's something that competition authorities need to factor in to their assessments. So you have this interconnection between the two. But we can also see, as I said, that there are gaps in the competitive analysis. And I think the most intuitive example here is the one of mergers. So earlier this year in the UK, the Competition and Markets Authority commissioned a Lear report on digital mergers. And so this was a retrospective analysis of certain digital mergers. And there are some of the statistics around mergers from that report are quite striking. So you see that in the decade from 2008, that a company like Google acquires 168 companies, Facebook acquires 71, Amazon acquires 60. The point being here that a lot of these mergers went unnotified because of the rules around turnover and the requirement to notify under competition rules, which means that it's hard to get a sense of the bigger picture. It's hard to see the wood from the trees, and the image I think that you see there is one of consolidation of market power in a way that is relevant for data protection. And so if you look at something like the Facebook-WhatsApp merger, when that was notified to the European Commission, exceptionally, the Commission only took into account the impact of the transaction on effective competition. So it looked at the market for social networking services, the market for advertising, the market for consumer communications apps. And it said in none of these markets would this transaction pose any problems from a competitive perspective. However, I and others have argued that there's a blind spot in this analysis, which is that these acquisitions allow dominant companies to acquire a larger volume and a bigger variety of data, which in itself poses problems for data protection law. So what follows from that is that competition law starts to pose a problem for the effective application of data protection law by enabling this consolidation. And from a data protection perspective, consumers are then left, or data subjects, beneficiaries, are left with the take it or leave it choice, similar to the one that the German court recently left with consumers. And I think here there are two paradoxes in this situation. So one is that in that competition analysis, we see that the relevant acquiring companies are saying, well, the amount of data that you hold is not necessarily a competition problem, because data is non-rivalrous. It can be held by many companies at the same time. So this implies that there is an unnecessary collection of personal data. Well, that, for a data protection authority, should already be ringing bells. How, on the one hand, under competition law, can we say this data collection is not necessary to compete or necessary for the business model, and then under data protection law, that be compliant with principles like purpose limitation and data minimization that are there to safeguard individuals? So I think that's something that requires further assessment. But then the second thing that this is setting up is a situation where then regulators want to divest the big tech companies of their data. So on the one hand, through a facilitating mergers and acquisitions system, we're allowing data consolidation. And then on the other hand, we have presidential candidates, for instance, in the US, campaigning on the basis of the divestiture of that data. And so this was, or is, an entirely avoidable situation if competition and data protection works in tandem. And I think it's possible for these two areas of law to work in a complementary way by, first of all, integrating data protection considerations into competition analysis. So looking at data protection as an element of product quality, which I think we'll talk about later. And then by also recognizing that there are certain circumstances where data protection as a fundamental right will put a block on what a competition authority can recommend, for instance, or will act as a brake on competition law. And I hope we'll also get to talk about that.
Thank you very much. So let's move now to the other side of Atlantic and a little bit different position that the FTC plays in the field of data protection and the competition at the same time. Rohit, what is your opinion on the subject? I know that you have quite a strong one about it.
Well, thank you for having me, and thank you for having this conversation. We are at such an important moment as we think about the intersection of competition and data protection and consumer protection, because for me, it is all about abuse and misuse of power. And I live in a country that has always been a hotbed of innovation, of creativity, and entrepreneurship. But I fear that we are moving away from that as our consumers and our businesses have fewer choices about how they will get to market. And we are seeing venture capital drying up in so many sectors. And I'm worried that our economy is in many ways looking more and more like that in China, where politically connected few companies really hold all the cards. So for me, and the discussions I've had in the last few days with regulators from around the world, is we understand that if we are going to fix some of these problems, it can't just be with a rule here or a regulation here. It is going to have to address the fundamental structure of some of these firms. And if we do find that they engaged in misconduct, particularly anti-competitive conduct, we need to start thinking about remedies that will actually fix the problem. And those remedies are going to have to mix all of what the disciplines we bring to bear. And I want to name just a couple, because we have to think about privacy as a clear point where companies compete on. We want the marketplace competing on privacy and not having take it or leave it contracts where more and more data is vacuumed up. And we want an economy that's innovating, where everyone can challenge the big guy. And we don't know what the world would look like if Google did not buy YouTube or if Facebook did not buy WhatsApp. We simply do not know. So in our investigations, we're going to have to get to the bottom of that. In the United States, the FTC is investigating digital firms. We have scores and scores of states' attorneys general who are doing the same, and I stay in constant communication with them because this is truly an all-hands-on-deck moment. But remedies is going to be one of the toughest things we have to think about. And a few come to mind, and we have been talking about them the past few days. And one of them for me is about open technology. How much are we going to have open source technology like email or like phone numbers that allow people to cross-talk across networks in ways that protect privacy and security? In the United States, the Communications Act provides some framework for this. In our telecom sector in the United Kingdom, there's the Open Banking Initiative, which dealt with a lot of these similar issues. Another remedy we have to think about is clear, bright line rules about bans on certain types of business practices. Sometimes we just need to trust that the market will innovate in ways that are safeguarding public protections that we as the public and as regulators are imposing. And finally, we need to start looking much more clearly in investigations across both data protection and competition about individual liability. I think we are increasingly in a global environment where we believe that companies have no individuals who are calling the shots. But in reality, investigations that do not assess the role of individuals will never be able to fully correct the deficiencies that caused misconduct. So we need to continue this conversation about remedies as it relates to privacy and as it relates to competition, because we simply cannot pull them apart. And there are many historical antecedents that address some of these issues that we can learn from and build from. Now, of course, that is not to say that breakups are not on the table. Breakups will always have to be part of the toolkit for a competition regulator, but we must also address the unique circumstances we face in today's digital economy.
Thank you very much, Giuseppe. I said that Italy was always in the front run of the discussion, and Italian authorities have never been afraid of using innovative tools in order to regulate the market. I always will remember the story of one of the privacy officers of one of the big players who had to resign from going to Italy for vacations because one day he was detained for the activity of his company. So even the penal courts had some innovative solutions. How does it look like from the position of the DPA, who is involved in the discussion about the competition tools?
Yes, thank you for this opportunity to speak here. We had also a decision from our competition authority on Facebook that is based on the consumer decision, consumer rules, but also on the consideration on data protection rules. And we are trying, and we know the importance to collaborate and to make a change with the competition authority. For instance, with competition authority, a communication authority, we launch a common stakeholder consultation on big data and also a coordinated position paper, and we adopted it. But I will return on that. I will return also the risk that we have if we don't have cooperation between these bodies. But in general, speaking in general, I think that learning from the decision of the German antitrust authority and the Italian antitrust authority, we can have an interplay in two levels. The level of consumer protection, and in this sense, we have the possibility to help and reinforce the competition decision regarding fairness, transparency, free consent. I am sure we return on that. But more than that, and this is very important about data concentration and antitrust problem, we have a key element that is the purpose limitation principle, and we know that under data protection law, the data have to be collected to specified explicit purpose. That means that it's not acceptable that the data are collected for a very broad purpose, has happened. Company that say to the user, say to us that they have to make people happy or to make the world better. That means that they would have the possibility to collect the data, all type of data, for all type of purposes. And this is not possible. And this link strictly with the logic of antitrust law, because it's not possible to allow to collect too many data without specifying and without explain to the consumer, to the user, which is the real purpose. And the other element about that may put strictly the competition logic with the data protection logic is the fact that is the enrichment of data. That is an element that is well known on data protection authority, because if a single data about a new person is coming in hand to a company that has a lot of data, then this company, because of the data that is owned and is in the availability of this company, knows to this person more than the person has said, more than the data that have been communicated to this company. And this is different if these data are given to a company that has a lot of data. The possibility to enrich the data of a single person show that the construction of big data, big database is a risk both on the economic point of view, antitrust point of view, we can say, and also from the point of view of course, data protection. And I think the last, we will go ahead in this discussion, but in my opinion, the most important thing is to say that also if we consider only the economic perspective, the economic point of view, we have in many cases imbalance relationship between the user and the company, because the data can be reused many times. And so when we have an exchange, a service versus my data, good versus my data, I keep one time the service of the good, but the data can be used many times. And this is a disequilibrium, the synalagma of the contract is not respected. But, as I will finish on that, as Data Protection Authority, we know that this imbalance is not enough to consider economically at the economic point of view, because we will know, and we said during the day, during these days, is not only the problem of economic protection of the person, but there is the need to a protection that is broadened, that we speak about fundamental right. We know that the use of data have an implication on all the field of the person life and also of the society. We spoke about politics, and we will return on that. So we need, and this is the most important thing, we need to embed, to put some logic. When the competition authority consider and the exchange of data and the personal data and consider as a good in the economic exchange personal data, they have to embed in their decision something of our logic, of the data protection logic, because the only way to have the whole picture that is more complex, much more complex, and this is the key element that we can give to our colleague of competition law to reinforce their decision and also to protect all the user or the citizen. Thank you.
Thank you very much, Maria. You are coming from the other side of this discussion, representing those who are dealing with competition law. Sometimes we hear that there is a pushback from the competition authorities who think that the tools that were working well for their activities are now going to be reused for something else, for some other purposes which they were not created for. Is it true that there is something like that?
Whether you mean whether the competition authorities as a whole have an issue with incorporating data protection within competitional analysis. I would like to distinguish that in a way, because we've heard many interesting ideas in the opening remarks of my fellow speakers here. And for me, these are two separate questions. It's a different question to incorporate data protection within the traditional competition law analysis and privacy as a fundamental right. But I would like to come back to that. I would like to start by introducing a concept which I think kind of contextualizes many of the problems that we see in digital markets with respect to excessive data collection. And this is the concept of digital agoraphobia. And since I recently joined the Greek Competition Authority, I thought I would come with a Greek term. So agoraphobia is the fear of the marketplace. So if you translate that to the digital world, what we see increasingly is that consumers, they feel that they're losing trust in their transactions online. And this is particularly problematic when the currency that we have in online markets is our data. Now, it has been suggested by competition law scholars that this is a non-issue because we're not paying with that and we're getting something back in return. But this only offers one part of the story. This is only one side of the bigger picture. And this has been discussed by the German Competition Authority in the Facebook case. And interestingly here, I was reading a study in New York Times where the author of that study, they reviewed more than 150 privacy policies of big digital platforms, amongst which was Facebook privacy policies. And they used meta-metrics analysis to suggest that when you read Facebook privacy policies, first of all, you need around 20 minutes to read it. But on a scale, Facebook privacy policies policies are more difficult to comprehend than books like The Brief History of Time or Great Expectations. So it's really difficult to comprehend what you're reading and what you're consenting to. And this seems to be one of the issues that the German competition authority, the Bundeskartellamt, discussed in the Facebook case. And there is a quote that I quite like there. The Bundeskartellamt said that when the choice is free, it amounts to a loss of control, which is something that the regional court in Düsseldorf seemed not to agree with. But it is really an issue. Now, I would like to make 2 points with respect to the German Facebook case, which is one of the cases against Facebook that we have in Europe, and it was mentioned also that the Italian competition authorities, the Italian competition authority has looked into that. Now, for me, we need to make a distinction here. First of all, the German Facebook case is unique. It applied German competition law, and German competition law is rather progressive in its application in digital markets. That's my first point. The second point is that the Italian competition authority has competencies not only with respect to applying competition law, but also with respect to applying consumer protection law. And for that Facebook case in Italy, the application was consumer protection law. So it wasn't really, we didn't use the tools of competition law as such. Which I think it's something that we need to bear in mind. Which brings me to my last point. How should competition law be applied to address this new reality? First of all, and it has been mentioned before, we can keep the traditional paradigm, and we can debate what we mean by traditional paradigm, but we can see we can view privacy as an aspect of quality. We can incorporate it within the notion of consumer welfare. We can look at excessive data accumulation as a sort of market power concern, or we can use privacy as a sort of fundamental right by using a more teleological approach. And this is more difficult to incorporate it within the competition law tools as we have them. And this is something that, again, the court in Germany seems to have taken issues with. And my last point is that brings to the forefront our role as competition authorities. And we need to remember what is our toolkit. For example, the Greek Competition Commission only has competencies to apply competition law. It's not the same with the Consumer and Markets Authority in the UK or the ACCC in Australia. So the question is, do we want to convert competition authorities as a type of super regulators? Do we need something else? And that will be open for discussion. My last point is that we can look at other tools that competition authorities have, and that's something that the CMA is currently looking at in the UK. They have a market investigation on online advertising, and that echoes the ICO opinion with respect to problems in those markets. So we'll leave it up to that, and yeah.
Can I just build on one point that Maria mentioned, which is that in competition law analysis, it's a common point of focus is price and quality. So when it comes to data and free services, this is a really interesting exercise because many people think, oh, well, the service is free, they didn't raise the price, and we ended at there. I mean, that's completely wrong to me. Mm-hmm. Data impacts both price and quality. So on price, we are paying for these services with our data, and that data is valuable, and we all know that. And so to what extent, if you do have market power, like Maria is saying, are you able to unilaterally increase your price in the form of sweeping up more and more data? That is the price effect to me. Obviously, the quality effect is to what extent are firms competing on a quality indicator, which is you would much prefer there to be less of your personal data being taken from you than more, without your consent or without your clear consent. So the price and quality analysis is going to be very important as competition authorities analyze these problems and ultimately craft remedies that go and attack directly this misnomer of the free service.
Okay, yeah.
that. I agree. I agree with Rohit's point. And actually, I was watching recently a TED talk where it was suggested that the most dangerous price is free. So I agree with you on that. It's not really free. It doesn't have a monetary tag on it. But translating that to workable tools, it's what is missing at the moment.
Okay, I think that the investigation from the Bundeskartellamt in Germany was the first, the first attempt on the national authority to look to the specific market in digital realm in a holistic way and address the harms which may result from the dominance with the convergent approach. To which extent the privacy and data protection can constitute the valid benchmark for the competition law analysis? How do you think? How can we really help in all this process? Question to everybody.
Well, I personally think, just to reiterate, I think we obviously are a data protection, consumer, and competition regulator. But I think the conversations we've been having the past 2 days is that it's more and more important, as actually we had just heard, that when crafting remedies, to be able to team up and be able to bring the best thinking and analysis, because to me, we're at an inflection point where there's a lot of major investigations with respect to violations of privacy law, GDPR, whatever it may be. There's a lot of investigations with respect to violations of antitrust and competition law. But the end result can't just be a dollar number that a company pays and moves on with. The remedies that we design together to protect all of these issues, ultimately, we all need to team up, not only in our own country, but globally, to make sure we get a result that ultimately fixes the problems.
Ulrich.
So the antitrust authorities are aware of the important role of data and data protection in their ongoing work because of its data-driven business cases. And there is an exchange on the national level. I know that the EDPS started an exchange on the European Union level. And now this exploring of the limits to show other amendments to make on data protection law or competition protection law on the other, antitrust law on the other side, to make it possible to work on the same topics. We tried that in Germany in 2017 with the amendment, giving data a factor in the in investigating market power and giving some role in consumer protection to the antitrust authorities. And this interconnection between data protection and antitrust work can also affect other parts of the work. For example, when the copyright directive was discussed in the European Union, after some exchange, I commented on that because we expected that the introduction of filtering techniques to fulfill the copyright directive will lead to another gain on market powers of those companies who can afford to build these technologies and offer them as a service to third parties, like they did with SDKs and other technologies now collecting data from different sources and bring them all together in one profile about the people trying to stabilize their market power by this way.
Yes, Ola, I think you wanted to say something?
Yeah, because if we think that competition law seeks to enhance consumer welfare, and that is defined as lower prices, better quality, more choice, more innovation. So as we've already heard, price is no longer kind of tangible in markets that are offered for free at the point of access. So then we need to shift competition attention to price and quality. But as Maria has also highlighted, this is where competition authorities get in kind of deep water because quality can be more difficult to assess than price. But I would say here that it's not impossible. So where traditionally competition authorities have reached out to economists in order to gauge increase in prices, what needs to happen here is competition authorities reach out to, for instance, data protection experts in order to gauge whether or not there is a decrease in the overall level of data protection quality or data privacy quality of a particular product. And so again, the counter argument is, well, what benchmarks would we use? But I think based on discussions this morning, we can see that globally there is convergence around some core principles of data privacy law, the fair information practice principles or the safeguards or principles for data processing. So you could pick out some of those principles like data security, purpose limitation, data minimization, and assess competitive conduct against those benchmarks. So this isn't impossible, it just means rather than turning to economists, we turn to technologists and other lawyers. And again, here what the German Competition Authority did was to use data protection as a kind of a bright line rule. So to say if you infringed data protection law, then that would be a competitive harm. But I don't think you even need to go that far. You could simply say if you seriously deteriorate the quality of data protection offered, even without interfering with competition law, that in itself could be a competitive harm. This could be a relative benchmark, like in predatory pricing. So it's about going back to those traditional tools and rethinking how they fit to the business models that we now see online.
So let me be provocative for the first time. I also hear from the data protection authorities that it's actually the mistake to use the approach as it is taken by the competition authorities, because the main role of the regulator is completely different, because the aim to be achieved, the purpose to be achieved by the competition regulators is to have well-working market, while the data protection authorities are protecting the fundamental rights. So the compromise from the fundamental rights perspective in order to have a well-working market sounds heretic among the data protection authorities. Is there a threat like that? I don't know. That's once again the question to everybody.
Maybe to avoid this risk, we have to consider that when the good considered by a decision is the personal data, we speak about freedom of people. So we have to, when I said to embed in the decision of competition, antitrust decision, the logic and the decision, maybe procedurally, because I am thinking of a process where if the good is personal data, then the data protection authority, using the principles that are minimization, purpose limitation, and so on, has to check and to evaluate if the use of data, the process is fair or unfair. And then, above this decision, there is the possibility to build up the decision of the competition authority. In this way, you keep you have a procedural collaboration of the two authorities, and you have also the safeguard of the fundamental right. Otherwise, the risk, if there is no this kind of procedural collaboration, is that will be in the same case, in the same issue, different positions, and then will help the company that infringe one of the other law. And also, there is the possibility that if one authority decide before the other, when the second authority will decide in the same case, for instance, Cambridge Analytica is the case of Italy, there is the possibility to have in front of the judge the possibility to the ne bis in idem principle that impede the more than one decision on the same case. That means that the second decision of the second authority will be considered by the court illegitimate, the second camp. So I think that the way, the need to collaboration is to know that when the good, when the element in the exchange are data, then we have to keep to the data protection authority that has a strong, a deeper possibility to have a deep evaluation of the case, the evaluation of the fairness on fairness. And then the powerful instruments and tools of competition authority can be used in the better way to protect integrally the user.
Yeah, I think that's right. And I think what Professor Linsky said earlier was very important, was that there's a lot of limitations of how economists apply tools in the digital economy. They're pretty lousy about predicting, the models at predicting entry and deterioration of quality when it comes to some of the indicators that she mentioned. So for me, I think a lot of data protection regulators are realizing they need a lot more technologists rather than economists. And I think also competition law enforcers are also seeing that they need technologists more so than their economists sometimes, especially when crafting remedies. Because I think the conflict that you mentioned about it butting heads, I think that's a little bit overstated. Yes, there are going to be times when an antitrust regulator wants a company to share a customer list. I think those examples are not as long as the hysteria is made out to be. I think this hysteria sometimes is provoked by companies that fear cooperation from regulators of different sectors, because ultimately many of the solutions that we will be able to achieve if we find misconduct will both advance the twin goals of more competition and innovation, as well as greater rights for consumers and protection of privacy.
But Rohit, let me ask you, I know that you had a different opinion about the recent cases in the FTC where the sanctioning powers were used, or rather at least the threat of the sanctioning power made the settlements between the FTC and the players on the market something which we somehow are lacking in Europe. I mean, the people are asking, where are the big sanctions? But I know that you said at one stage that the sanctioning does not solve the problem.
Well, both the Facebook and the YouTube privacy cases were important actions. However, my concern with them is that the companies still came out ahead, and that big fines for the biggest companies are really not big penalties. And so in my own analysis of the data, I believe that YouTube's child privacy violations were very, very lucrative, far more so than the $170 million fine. But it was an important action because it showed our willingness to actually do something. Now, that being said, I don't know if the remedy I don't think is going to fix the core problems at Facebook. It's certainly not going to fix the problems at YouTube. And in both of my statements, I talked about the role these data abuses were in advancing dominance. And to me, I forget if Maria or Professor Linsky mentioned network effects and tipping of markets, tipping meaning that everyone is going to one or two players. That can be a major motive for data abuses. If you quickly want the whole marketplace to converge on you, boy, are you going to want to take as much data as you can, early on and sometimes illegally. But if you do it illegally, there has to have consequences. And for me, the dominance and the violations there go hand in hand with the violations of privacy, which is why remedial actions must take into account both the motives and the incentives of these business models.
We have the question from the audience. Let me ask you, Ulrich, I think that's a question to you, but also the question to all of us. Isn't Bundeskartellamt case a way to circumvent GDPR? Isn't the way to circumvent the one-stop shop?
The decision of the Bundeskartellamt, it's a way around the one-stop shop. No. It's not a question if the background of the work of the different authorities is the same, that means individual rights or GDPR, but if they contribute to the same idea. That means a digital market, a digital society with the freedom of choice, with the plurality, an open exchange of ideas, and in the moment where the collection of data is not just an obvious violation of the GDPR, but an abuse of market power, it's a question of the work of the antitrust authorities. If the breaking of cybersecurity is endangering data protection, it's even a work for cybersecurity agencies on the national level. The question is, as long the European Union has different ways of coordinating the work of national authorities in the data protection, in the antitrust, and in other parts of its law. That's a good question, but as long as there is a difference, not one of those ideas can just overrule all the others. So I don't think it's a break to the one-stop shop, because the work of the services as its own, from the perspective of the GDPR, it's still inside the one-stop shop, but the one-stop shop system has to deliver. It's now 500 and something days after the start of the GDPR, so where are the decisions of the DPAs?
Maria.
Yes, I think, let me start by saying that in principle, and in theory, I like the Bundeskartellamt's approach to Facebook. It's exactly to the heart of what we're discussing here, having a competition authority taking this integrated approach. The problem, though, is, and I guess it goes to your point, that we all see the problem and we need to do something about it, and we need to craft remedies to address it. There is a market failure there. But at the same time, what the Facebook case in Germany exposes, I think, in a way, is the limits of the tools that we have. Competition authorities in all around the world, Fairman Review in the UK, the EU Commission report, Australia, the JFTC, in other member states as well. They take a kind of competition law approach to things. And what the competition authority in Germany tried to do is go a step further. And what it exposed there is that if we are to go a step further, we need to reflect in more detail how we're going to do it. Because yes, there is a problem with privacy. How are we going to make that into a competition law problem in a way that will stand the legal test as we have it? So I think that's an important point to bear in mind, because I see all the point that the tools are there. So say if I translate it in the legal text, it's the imposition of unfair terms in the transaction that we have. What the court said is that the Bundeskartellamt failed to meet the legal test. It didn't show that. Had it shown that, then there wouldn't have been a problem. But they failed in meeting the burden of proof in that case. So I think that's an interesting point to bear in mind, because in theory, we need to integrate the approaches. And going back to your point where we were saying that they may be conflicting at times, I see them as converging circles. So privacy laws, there's the human dignity element there. And competition law is about ensuring consumer choice. And consumer protection law is about giving consumers the information to be able to exercise that choice. So right at the convergence, that's where we need to all work together to come up with a solution that either will stay within the legal test as we have them, or we need to move a step further.
Yeah, I think we'd also be remiss in not, it's important to talk about what's happening in Germany, but we should also look a little bit about what is happening in Japan. Recently, in Japan, there was a public consultation about click-through terms of service. The I agree to the terms and conditions. And in Japanese competition law, they rely on a principle called abuse of superior bargaining position. And the extent to which they analyze competition problems as where does one player have so much market power that they can abuse it? And ultimately, do they use that to compel consumers who have almost no choice, they can't negotiate, to agree to certain terms? And to me, as I said before, that's the equivalent of a price hike or a quality deterioration. The concept, I think, fits into many different types of law. But again, like Maria said, we all have to think hard together, again, globally as well as sector regulators, as what is the remedy that is ultimately going to turn off that business incentive to abuse and misuse personal data.
A very short point. I think it was in the EDPS report in 2014, there was a statement that I quite liked. In that report, they stated that when there is dominance, well, basically consent is illusionary. There is no consent because you have to go with that. And that's something we need to bear in mind. Yep.
I would say, okay, but we have the question about convergence and the other way movement from the audience to Rohit. What about the differences in the Child Online Protection Act, which you are dealing with as FTC, and at the same time California Consumer Protection Act, where there will be another body who will be dealing with the subject?
Just if you could repeat the question one more time, was it about
okay, well,
the
so
children's
I will read it precisely as it was asked. Let me now find it because I lost the...
It's okay. There's obviously for 20 years the U.S. has had the children's online privacy protection.
Precise question is, for the FTC, what is an interplay between COPPA and CCPA when there are two authorities, FTC and Attorney General of California, respectively?
Well, I hate to break it to some in the industry, but sometimes you have to comply with more than one law from more than one authority. In the U.S., our state laws are important. They provide a lot of protection for consumers and reflect some of the individual preferences and economic circumstances of our states. I have shared that I am opposed to broad preemption in any federal law of state laws because we have lived through this mistake before in the subprime mortgage crisis where federal law invalidated important state law protections and the harm was enormous. Now that being said, of course regulators have to work together. I talk to state attorneys general all the time. Even the YouTube action, which I did not support, I'm glad that the FTC worked with the New York Attorney General on it. So I hope that once the California Attorney General begins to enforce the CCPA, that will be another opportunity to use our various authorities and leverage each other's resources to ultimately fix some of these problems. Now, the FTC, for what it's worth, is doing a review now of some of our children's privacy rules. I know it's of interest to many around the world. And I hope that whether it's the California law, whether it's the US law, whether it's other laws, we look at business models like TikTok and use every single tool we have to stop harm, especially against children, in ways that can endanger them.
Okay, more general question from the audience. Can competition law address power and inequalities between the platforms and the data subjects concerning consent?
Maybe consent, if I can. Consent is the example that has been done when a company has the power, because of the data that in its availability, has the power to impose some condition, and was the example that has been done, then the consent is not free. And our that means that this data with this consent can be used, sent to other companies and used for other purpose. Our protection of fundamental rights stop this possibility, and then we have the possibility to reinforce the decision both on the data protection point of view and competition law. We have, considering the whole picture, and we have the possibility from data protection law to highlight the risks that are much more bigger than the risk to have to pay more a service, to pay a fly in the, more than the real price. We are speaking about freedom in the very bigger in the whole meaning. So the protection of fundamental rights can be the basis and can help the decision of competition authority. Consent and free consent, and also the fairness, considered not only in the from economic point of view, but from the more the deeper meaning of the data protection, can help to have not only a market, a decision that apply to market that allow to have a good decision of, in the market, but also to keep in the digital world the freedom that we need and can be, and is at risk at the moment.
Ola.
Yeah, so on consent, it was that issue specifically that the Bundeskartellamt had looked at in the Facebook Germany decision. And I think there are two striking things about the judgment that recently overturned the Bundeskartellamt's decision. So the first is, I think if you looked at this from a data protection or a privacy perspective, you would think the wheel is being reinvented. A lot of the discussion around consent is very one-dimensional. It was like, you signed up to these contract terms at this particular static point in time, therefore this is an accurate reflection of what the market demands. Whereas, of course, in data protection law for decades now, there's been a lot of behavioral economic analysis and a lot of social and sociology analysis that illustrates this is not the case. It is a decision that is made with a lot of different factors in mind, including not leaving yourself professionally and personally isolated, rather than an endorsement of particular terms and conditions. But the other thing that I thought was striking, and I think this will be an issue for competition authorities worldwide, and something data protection authorities need to be aware of, is that in that case, the court insisted on the counterfactual. So would this conduct, this excessive extraction of data or this exploitative kind of consent have been possible in the absence of market power? And here, I think dominant companies could say, well, this happens, people consent in this way irrespective of whether a company is dominant. But I think that masks the fact that we have a market failure, that there is a dysfunctional equilibrium, and an FTC economist wrote about this in 2012, whereby we have never seen the emergence of data protection, data privacy friendly practices, and that's because of this vicious cycle where we're faced with boilerplate terms and conditions, they're never ending. There is a rational disengagement by data subjects who say, well, they're all the same, I might as well just click yes. And that in turn means that we don't see innovation emerging around privacy-friendly services, and so on and so forth. And so the counterfactual here is kind of a red herring. If we rely on the counterfactual, we're not going to get good competitive assessments because there is a kind of a persistent market failure.
Ulrich.
Just a short comment on the Facebook Bundeskartellamt case. So the case is not overturned; it's just suspended, and the Bundeskartellamt will seek a decision in the main topic, and that could be very different. Now, with some of the thoughts, they say the harm to the company could be greater if, in the end, the main decision is quite different to the order of the Bundeskartellamt. But that's important for me. Just suspend it.
Okay.
Not more at this point.
before we'll come to conclusions, and my last provocative question, I have the American question to American Commissioner. Why has FTC not required Facebook to divest WhatsApp? The company violated its representation to FTC about segregating WhatsApp users' data. Even WhatsApp founder quit the Facebook board. Why has FTC not acted?
The chairman and I disclosed in testimony to Congress a few weeks ago that Facebook is subject to an ongoing open antitrust investigation. State attorneys general led by the state of New York, I believe over 40 of them now, are also pursuing an investigation. No one should prejudge the outcome of that, but of course, if there is unlawful conduct, divestitures and other relief may be appropriate depending on the facts and circumstances. But more generally, I hear loud and clear the point from entrepreneurs, investors, consumers, and everyone that if enforcers do not take seriously what is happening online in our digital economy, the US and other democracies will fall behind when it comes to innovation and when it comes to creating broadly shared prosperity, and that's something I take very seriously.
Okay, thank you. Well, we have more or less 3 minutes per person to summarize the discussion, but I would like to ask the provocative question as the, let's say, starter for this summary. Well, looking at Peter Hastings here in the room, I'm tempted to ask him, do you see any progress in our discussion about competition law and the data protection law and the convergence? But I'm not going to ask this question to Peter, but I would like to ask you, if we will meet in 2 years' time or 3 years' time, will we be still talking about the same problems and the same challenges? Did we make any move? We have some cases that we are talking about, that's true. But are these still the same questions that we are answering as we did in 2013? Or are we making the progress and we see the possibility of the progress in the nearest future? What's your point on that? I know nobody wants to start, but...
Maybe 2 years is too long time. We have to find a way to collaborate soon. Otherwise, we lose an occasion that is very important. It's not possible to allow some possibility to accumulate so many data to dominate people. And this is a task that we have together to avoid the concentration of data that can put on risk our freedom worldwide. So the task that we have, not only in 2 years, but before, is to do today, tomorrow, to find a way to put together all the instruments that we have, all the tools that we have, keeping together the tools that each one of us has the possibility to enforce and try to put together. 2 years will be too late.
Who's next?
Well, I think that depends on two sets of groups. One is obviously the business community. So if I reflect 20 years ago, the massive lawsuits by the US government and the state attorneys general alleging serious misconduct by Microsoft with respect to anti-competitive behavior. I think those actions ultimately safeguarded the open internet, and there would be no Google, Facebook, or Amazon, in my view, without that action. So I think the more our industry can actually embrace the concepts of transparency, competition, and rule of law, the better off they will be in the long term. And I will note for the record that Microsoft, despite being sanctioned, is worth approximately $1 trillion today. So it didn't go away. The second, I think, depends on the group of regulators in this room as well as regulators in the competition sphere, is that if we have the will and the analytical horsepower to work together and craft serious investigations, serious analytical tools, and serious remedies, that gives me a lot of hope for and optimism.
Orla.
Yeah, so I would certainly think that there's been a lot of progress made since the European Data Protection Supervisor kick-started this discussion 5 years or so ago. You see some enforcement activity, but I also think from the bottom up, you've seen that within competition authorities, there's a real awareness of this issue. So Maria has already mentioned, the Furman report, the ACCC report in Australia. We've seen lots of initiatives around this, but I think the next step is to actually implement a lot of the convergences that are being explored as a theoretical option. And so there, I think it's quite striking that if you look at something like the European Data Protection Supervisor's Digital Clearinghouse Initiative, out of a total of, I think it's 86 or so authorities or 90 or so authorities in the EU, 20 to 25 are kind of consistently engaging with the clearinghouse. So I think first thing we have to say is why. So I can see that there will be a strategic risk for regulators to engage because this could kind of encroach on their turf and resources are limited. But I think the flip side of that is that it is very inefficient to duplicate regulatory efforts at this point in time when we see that resource constraints are having a significant impact on the effectiveness of something like data protection law. So I also think from a rights perspective, if you start to look at these issues in the round or holistically, you will end up in a point where you have kind of more coherent, effective fundamental rights. So for that, I would see that this cooperation is absolutely indispensable and that the next step or initiative has to be looked at procedural ways to overcome hurdles like those around confidentiality, resources, nibis and nidum has already been mentioned. So ways to avoid kind of pitfalls of this increased cooperation between regulators.
Maria.
Yes, actually, I agree with both Orla and Rohit, and I'm also optimistic about it. And even if you look within the competition law discipline, the last 3-4 years, the debate has shifted a lot. So that's the first point. But the second point is that at the same time, we also need to be pragmatic, and we need to see how we can work together, what are the tools that each one of us has. And from a competition authority's perspective, I think we definitely need to be more extrovert in our priority setting and also explore, as I mentioned also before, other tools that we have. It's not just kind of going after companies, it's also having an idea what's going wrong in markets. So market investigations is a good tool to get a grip of what's happening and work on remedies going forward.
Okay, Ulrich, you have the last word. Well, I had to learn the word Bundeskartellamt last year. That's almost as difficult as for Chris to learn how is accountability in Polish. So definitely there are some achievements in Germany.
Some questions will be the same in some years from now. Some topics will vanish with the technologies they come from, and maybe from some decisions of the competent authorities, especially in the now dominating markets in the US and Europe with its marketplace idea. And some new challenges will be there, some from new technologies coming up. And another challenge will be services and products for markets where the possibility of enforcement is not there at these days with independent DPAs or decisions by courts. So a part of the questions will be the same, but there will be others to discuss about, and the question how to enforce these rights outside of those markets which are represented through DPAs at this conference.
Okay, I think that's actually the time to go to the summary of this discussion. We are staying active in the role of those who are asking the questions, who are not surprised that we don't know all the answers, but who would be ashamed if we will not ask the questions about this kind of cooperation. The EDPS has created the Digital Clearing House, the idea which we right now continue with cooperation with academia, trying to get to facilitate the exchange of information and facilitate the exchange of knowledge, but also to get some assessment from outside on what's going on in this subject. I would like to thank all the panelists for their participation in today's debate. I'd like to thank all those who asked the questions to the application, and thank all of you for listening once again about the convergence between the regulators. Thank you very much.